welcome everybody. This is going to be the second out of 5 trainings, so if you missed the first one, don't feel bad. We'll cover most of the relevant information, and we'll hopefully early next week have a video of that uploaded. We will be recording today's training, just so you're aware. And if you would like us to stop recording, if you have a question or anything like that, just let us know, and we can do that. So today's training is going to be about withholding the rent, and what you need to know if you decide to do it. Withholding the rent is definitely a tactic that a lot of tenants have used to try and get conditions fixed in their apartments in the past, and we just want to talk about what exactly goes into that decision and when it's the right move to make, because it's definitely can depend on your situation. It isn't a blanket thing that anybody should withhold the rent over any purpose, but we want to make sure that it's utilized in the right way. So today's agenda, we're going to cover, just kind of the basics around withholding the rent, what exactly the goals are of doing it, and how to achieve those goals, how it impacts eviction cases and other sorts of court cases as well. And then we're going to talk a little bit about community tenant advocates and what their role would be. So as a part of kind of this larger partnership between PUSH and Neighborhood Legal Services, we plan on helping to train different community members to help advocate for other tenants that they know, especially when they're experiencing conditions issues. We'll touch on that at the end of the training, exactly what that process is going to look like. But we do encourage people to share their email addresses. They're interested in trainings on how to be a community tenant advocate. It's one of the trainings that we're going to plan on doing in person. So right now they're put on hold until it's going to be safe to do so. I am going to send in the chat really quick a link to the Google Drive where you can find this slideshow and some other materials as well. So just kind of a little bit of a recap on what our first training was about. It was mainly about what the warranty of habitability is, which is the guarantee that's afforded to all apartments in New York State, that your apartment's going to be safe and livable. It applies for all apartments, even when they're rented as is. A landlord still is required to make sure it's a safe, livable place to live. It's something that comes up in eviction proceedings as a potential defense to, explain why non-payment may have happened. And we'll talk more about that today a lot with withholding the rent and how it comes up in court. But this is specifically for conditions that threaten health and safety. Now, that's a very long list and can encompass a lot of conditions issues, but not all. If the paint is chipping and peeling and it has lead, that's a condition that threatens health and safety. But the paint just having done like a little bit of a shoddy job or having visible streaks and things like that isn't necessarily going to rise to that level. So we thought it was important today, when talking about withholding the rent, just to kind of recap again, some of the big conditions that we see often that are things to withhold the rent over or do violate the warranty of habitability. Again, we'll get more into exactly how to withhold the rent. It's not just, I saw a mouse, I'm not going to pay the rent next month. There are steps that we will want tenants to take to help protect themselves if a landlord does decide to evict. But these are serious conditions that affect health and safety and would be considered violations of the warranty of habitability. Many of these are, obvious how they can impact health and safety. Things like no water, obviously. Things like no heat in the winter, that's going to threaten your health. But other ones are less obvious, like having conditions that might make you a victim of a crime, like having a broken front door that is obvious that someone can just walk right on in. That is also something that would violate the warranty of habitability. So I'm going to pass the baton along to Alyssa and Grace. They're going to start to get into today's training.
Thanks, Jack. Can we go to the next slide? Thanks. So just to start off, it's important to mention that withholding the rent is different than just not paying the rent. Ideally, the money should be set aside when a tenant withholds the rent. It's not required that tenants put it in any kind of official escrow account, but it can be helpful to purchase a money order or set it aside somewhere just so that it doesn't get spent and that it is saved. There are some risks to withholding, but it can work when it's done correctly. And we'll talk about the risks later. Just on the next slide. The reason to withhold, like Jack mentioned, was conditions that violate the warranty of habitability. So that whole list of conditions that would likely violate the warranty of habitability, but it's not exclusive. And if there are reasons that don't threaten health or safety, it's probably not advisable to withhold the rent. And talking about a little bit about different types of tenancies and how that affects your ability to withhold the rent. If you're a tenant in private housing, it's still probably a good idea to speak to an attorney about doing it correctly first. But if you have a Section 8 voucher or if you have any other type of government subsidy, it's very important to do that because you could be putting your subsidy at risk if you withhold the rent. So we would definitely advise you to get the specifics of your situation reviewed by an attorney before withholding in any case, but particularly if you have a subsidy. And I think I covered everything on this slide. So before tenants withhold the rent, it's really important to give notice to the landlord about what the conditions are. And just as important is making sure that you document and keep copies of the notices that you've given to your landlord. So you want to make sure that you describe the problem that you're experiencing, talk about when and how many times you've contacted the landlord, how it is affecting you and your ability to use the unit, and then make a request for repairs and give a reasonable date for the landlord to do that by. After that, if the landlord still doesn't do the repairs, you'd want to inform the landlord that you do intend to withhold and also document that as well. Grace, did you have anything to add on to that one, or should we move on to goals?
I think we can move on to goals. Thanks.
Okay. So a couple different ends when a tenant decides to withhold their rent. Maybe the most simple scenario, maybe not the most common scenario, but in an ideal situation, you would just convince the landlord to do the repairs. So the tenant would inform the landlord of the problem, give a reasonable amount of time to fix the conditions, and if the landlord fails to do so, the tenant withholds. That persuades the landlord to make the repairs, and then the tenant goes ahead and releases the rent. Not always that easy. So there's a couple different things that could happen. In terms of a rent abatement, there's 3 ways to get that, and a rent abatement is where a judge would determine that based on the conditions that you have in your home, the amount of rent you're paying should be reduced to a fair price based on fair market rentals. So there's 3 ways that that can happen. You might get a rent abatement through a warranty of habitability hearing, and that can happen either through a non-payment eviction where the landlord sues the tenant for not paying the rent, or where the tenant takes the landlord to court in what's called an affirmative warranty of habitability case to try to persuade the court to either order the landlord to make repairs or to get that rent reduction. It's also that these kind of cases could end up in small claims court where either side could bring a claim or a counterclaim about monetary damages. So an affirmative warranty of habitability, like I mentioned before, the tenant sues the landlord for a rent abatement and seeking a court order for repairs to be made. this is where the documentation can be really important, because there are a number of different elements that a tenant has to prove in order to make their case. So the tenant has to be able to show that there's a tenancy, show that there are conditions, show that the landlord knew about the conditions, that if the landlord did something that it wasn't adequate or they just didn't make any repairs at all. They also have to demonstrate that it isn't the tenant's fault and that there were some kind of damages to the tenant. And then just quickly on repair and deduct, on the last slide, this is something that, again, it's important to talk to an attorney first, because if you have a lease, the terms of your lease could impact how this works. And it's typically not a great option for Section 8 tenants. Again, this could put your Section 8 voucher at risk, so this is something that you'd want to have reviewed very carefully before you took that step. But generally speaking, if you did want to take this step, it would inform, again, informing the landlord and documenting your effort to do so, collecting any kind of evidence you can about the conditions, maybe through inspection reports or letters to the landlord about the conditions. You also would want to get a number of estimates from reputable companies. Maybe not if you just know somebody who's a handyman who doesn't do it regularly, that might not be the best way to go. So you want to get, again, estimates if possible, get a detailed receipt once the repairs have been made, and present that to the landlord.
And if I could just jump in. So one of the reasons why we tell people to put the rent aside is because in our experience, it's very unusual for a judge to say that a tenant doesn't owe any rent. So what often happens in these cases is the tenant will withhold rent, and the conditions could be pretty severe. So let's say there's no heat in your apartment and it's wintertime. And so you're really not able to stay in your apartment or not able to stay there comfortably. What we've found is judges typically say, well, was there any value to having that apartment at all? And so some of the questions the judge might ask is, did you continue to leave your possessions in the apartment? Was your furniture in the apartment? And if the tenant says yes, then the judge will say, well, there's value in just having a place to store your possessions. Or if the tenant says, yes, I stayed in the apartment even though it was freezing, I used an electric blanket and a space heater to keep warm, the judge may surprisingly say, well, you stayed there and so that apartment has some value. So we always tell tenants to put the rent aside in a safe place, because if the judge makes the decision that the tenant owes money because the apartment is worth something, even with the unsafe conditions, then the tenant would have to pay the money that the judge says is due to the landlord in order to continue the tenancy. So the judge is making a decision about what the apartment is worth, even with the bad conditions. And at the end of the day, if the tenant wants to stay, has to repay that amount.
Thanks, Grace. So one other note on withholding rent. In some circumstances, tenants might have withheld money and then they end up using that money to move due to bad conditions. And there might be a lot of different reasons why a tenant would end up doing this. It's important to know, though, that you do have, even after you move, there's a risk that the landlord could sue for unpaid rent or other monetary damages in small claims court. You might lose your security deposit, and it's also possible that the landlord could obtain a money judgment. So I'll go over just the next piece, the overall risks of withholding. Like I said, small claims court is one of those risks, a lost security deposit. In addition, there are potential consequences for applying for housing subsidies down the line. So that's something to think about. And also there's a possibility of getting a money judgment against you. Those are garnishable depending on your source of income and could also affect your credit. And some housing providers will do credit checks. So it's possible that adverse effects to your credit could also affect your ability to find housing in the future. Okay, so there's a few different ways that withholding can lead to court, and we mentioned these a couple times already. So it's possible that the landlord could sue the tenant for a non-payment eviction. It's also possible that the tenant could sue the landlord for in an affirmative warranty of habitability case, and either one of these could lead to what's called a warranty of habitability hearing. There's some we have on the slide a list of the steps that a landlord has to go through to take someone to court for non-payment. And like Grace said, if the judge does determine that there's money owed, you have 14 days potentially from the date of court to have that paid off, or it's possible that a warrant could execute. And there are also some challenges, like Grace mentioned, to the warranty of habitability defense. Courts might encourage tenants to move rather than forcing landlords to make repairs. And if there are very serious conditions, and depending on the household composition particularly, the court may determine that it's just not safe for people to be living there at all. And also, like Grace mentioned, it's important to know that full abatement is rare. And even with serious conditions, judges will likely determine that you have to pay some of the rent. So these are the different elements, again, explained a little bit more that a tenant would have to show in order to properly make the warranty of habitability defense in a non-payment case, or if they wanted to bring the landlord to court for an affirmative warranty of habitability. So again, you have to have documentation, and there's some examples for each of the different elements that the tenant has to prove, examples of the documentation that would be helpful. And I just want to point out, as far as the, we mentioned in here reports a lot, and that refers to inspection reports from the health department and the Buffalo building inspectors, and we'll be having a separate training on obtaining and documenting with the assistance of those agencies in the future. So stay tuned. And it's also important to note that there is a possibility of the landlord retaliating against the tenant. If the tenant withholds the rent, the landlord could just give notice for no reason at all, in compliance with state guidelines about how long they can give notice. But the landlord can give that notice, and the tenant can claim retaliation. But if the rent isn't set aside, then retaliation isn't going to be a very good defense, because the landlord can really just say that the reason for the holdover is not retaliatory, it's because of non-payment of rent. So that's another reason why it's important to set that money aside.
Before we get into the section on community tenant advocates, are there any other questions about, the withholding the rent process, or what happens if you end up in court because of it? All right, so like we were speaking about at the beginning of today's training, we do want to start to train more community tenant advocates. We were hoping one would be able to join us tonight, but unfortunately she wasn't able to. Amina Johnson has worked for Push in the past and still does, and has helped a lot of different tenants advocate for to their landlord for improving the apartment. Really, we're trying to set up a similar model where we can train community members to help document for tenants the conditions that they experience in their apartment, and then be a witness in a court proceeding to testify that those conditions are present. It can be tough for tenants to gather all this documentation. I know Melissa was talking about how in a future training we're going to talk about inspection reports. Those aren't the only documents. They lend a lot of weight, but there are other ways to document. And regardless, they can be difficult to get. So a big part of our trainings for these community tenant advocates are going to be helping to gather documents from different agencies and also helping to document the conditions themselves. Understanding what sort of evidence of conditions lends the most credence to a claim when the court date comes, and helping a tenant stay organized with all the different forms of documentation. We'll be letting people know when we are able to undertake that training, but please, leave us your contact information if you are interested in becoming a community tenant advocate, and we will reach out to you when we get to the point where we can schedule these trainings and set up the system, have them going out to visit tenants' homes. I mean, obviously right now, with the current pandemic, we are not encouraging that in the immediate future, but hopefully soon it will be safe to do so. Get this program off the ground. Grace, do you want to cover the current COVID-19 and court situation as it's been evolving?
So this is an ever-changing landscape. Just making sure I wasn't muted. This is an ever-changing landscape, and we keep getting new information on this. But what we do know is that eviction cases have been suspended across New York State until June 20th, and that impacts all eviction cases in New York State. In New York State, there's also a moratorium. That just means there's not going to be any evictions heard until August 20th. If the case involves the non-payment of rent by a tenant who's either eligible for benefits under the state or federal unemployment insurance analysis, or because they're facing financial hardships due to the COVID-19 pandemic. There's also a federal law about evictions, and so federally subsidized tenancies. So that would include people who live in public housing in the Buffalo Municipal Housing Authority, people who have housing choice vouchers or Section 8 tenancies, people who live in housing that's specifically for tenants who are elderly or who are challenged by disability. Anyone who's a federally subsidized tenant should not be facing eviction anytime from now until August 20th. And this protection also applies to tenants who live in properties where the landlord has a federally backed mortgage. So that could be a Fannie Mae or an FHA, and there's a lot of different federally backed mortgages. And so one of the things that we'll be looking at Neighborhood Legal Services, if landlords start bringing eviction cases after June 20th, is whether the tenant lives in a property where the landlord has a federally backed mortgage. And we think that we'll be able to get that eviction case thrown out until sometime in August. After June 20th, it does appear that landlords may be able to start evictions against tenants for reasons other than non-payment of rent, or against tenants whose failure to pay rent is not related to the pandemic. But we go back to if the eviction is started against a tenant who lives in a property where the landlord has a federally backed mortgage, we may be able to stop that eviction. The other thing that's happening is that we don't know exactly when the courts are going to reopen. And so there's two orders really. There's what the governor says, and the governor has said, all eviction cases suspended until June 20th. And then in addition, non-payment cases involving tenants who are facing financial hardship, those cases are put off until August. But the courts are still trying to figure out when they're going to reopen, how they're going to hear cases, whether they're going to be hearing cases in a courtroom like usually happens, or whether cases will be held or heard virtually. And we also don't know how many cases each day the court is going to hear. So that could, even if a person fails to pay their rent and it's not, they're not facing a financial hardship and the landlord wants to start an eviction case, the number of cases that the court hears each day is going to impact how soon the landlord will be able to get his, her, or its case heard. The other thing that we know is that after June 20th, civil officers, at least according to the governor, can start putting people out if the tenant already appeared in court and they were supposed to be evicted but didn't get put out because of the pandemic. But even that is a bit gray. So the city court marshals are, usually if there's a delay between the time the court says, okay, you can put the tenant out to the landlord, and the time that the landlord, puts the tenant out, if that delay is more than 20 or 30 days, then the city marshals usually say to the landlord, look, you've got to go back to the judge and get the judge's okay for us to put the tenant out, or you have to start all over again and we have to issue a new notice. So we don't know exactly what's going to happen after June 20th. What we believe is going to happen is that the city court marshals may require landlords to issue a new notice before tenants are put out. We don't know that for sure. We do know that we have good communications with the court and with the court system, and we've been in meetings all this week and in the prior weeks, and that's going to continue. So we'll keep you posted. As soon as we learn more, we'll let you know. But there's a lot that's up in the air right now. The courts are pretty worried about sort of reopening their doors, about putting people out because there's so many people across America who have not been able to pay their rent. And the civil officers, the city marshal's office and the sheriffs, they're also concerned about what it's going to mean when people start getting put out. So as soon as we have more information, we'll share this with you, and we'll certainly talk about this as our trainings continue on. Just two other things though. Orders to vacate have not been stopped by the moratorium. So in situations where living conditions are extremely unsafe, the court still has the power to jump in and say that a tenant shouldn't live there. But on the tenant side of things, if tenants are facing poor housing conditions and the landlord's not making repairs and the conditions are severe, then the courts are willing to hear those cases. So Alyssa talked about affirmative warranty of habitability cases earlier, and those are cases that we can still file even while the courts are closed. They're considered an essential case, and so the courts will hear cases that involve housing conditions that are really unsafe. Should I carry on, or does someone want to talk about COVID-19 and poor housing conditions? I'll carry on. So, so as Jack mentioned earlier, there's a little reluctance to have people go into other people's houses, and that's one of the reasons why we sort of put a pause on the community tenant advocate program, because it's not safe right now from a public health perspective while the pandemic is going on to have people go into other people's homes. And the Erie County Health Department and the building inspectors have those same concerns. So they are doing inspections, but they're limiting their inspections to emergency situations. Certainly if a tenant doesn't have water, if the electricity is off, if the porch has fallen down, if there's anything that's very dangerous, we think that we can get the health department or the building inspector, whichever is the most appropriate agency, to go in and do an inspection. But if it's, ripped screens or a broken window, chances are we're not going to be able to get those agencies to go out. The New York State court system, as I mentioned, they're taking steps to gradually reopen, but it's just not clear how soon they'll reopen and when they're going to start accepting eviction cases. Even though the governor said yes, on June 20th, these cases can start begin to get filed and heard. We're not sure whether the courts are going to be open on June 20th or not. But while they're basically closed, they're still looking at essential cases in the landlord-tenant world, and the courts will hear cases that involve really unsafe housing conditions. for more information, our number is listed, and please feel free to give us a call, especially if you're faced with a situation where you're living with unsafe conditions. The housing choice voucher providers in our area are Belmont, the Rental Assistance Corporation, and the Buffalo Municipal Housing Authority. And right now, each of those agencies have different COVID-19 protocols for inspection. So you can call your case manager if you have a housing choice voucher, or you can call Neighborhood Legal Services, and we're happy to look into that for you.
One thing I did want to add related to the health department and building inspector, even if they don't come out and inspect, sometimes they may choose to send a letter to the landlord if the complaints are made in good faith. You know, there have been circumstances where it could be an exterior item that they notice or things of that nature. So even if the pandemic is ongoing and you desire to call the health department and building inspector, they may not come out to inspect, but that doesn't necessarily mean that it's not on their radar after you call. So I just wanted to take a moment to talk about the other services that Neighborhood Legal Services provides. Not only do we help out tenants who have bad housing conditions, you know, we cover all sorts of landlord-tenant issues. We cover disability law, family law, public benefits. We have health insurance navigators for people who are using the New York State Health Exchange or, you know, determining what sort of Medicaid Advantage plans to get, and also WIPA, you know, advocates for individuals who are on disability or SSI and are returning to work and navigating that system. We also do have a lot of informational sheets on our website, MLS.org, especially about the COVID-19 pandemic right now, but about all of our different, you know, services we provide. But also, like I said, on our COVID-19 page, we have stuff about unemployment and kind of just how different benefits are being affected right now by the pandemic. Angel, do you want to take a second to talk about the services Push provides?
So Push is a very large organization in a way. We have a lot of different departments. We were operating a mutual aid hub, but temporarily it is closed down for cleaning and sanitization. You know, when you're in contact with the public as much we are at the hub, it is important to maintain cleanliness, and there are plans to reopen it. However, it might not be for, you know, maybe another week or two after this week, just to be safe. We are an affordable housing organization, and so we do run affordable housing by state guidelines. We also do organizing work. I myself am the interim housing organizer there at Push Buffalo. So we organize around campaigns to pass laws relating to climate and housing, as well as we run a drop-in center for youth on Grant Street. So along with our organizing is our tenant advocate, who's Amina Johnson, who's been with Push since Push was even started. And so she is our tenant advocate, and she does take phone calls from the community and work on advocating for the community, and she goes to court, and so on and so forth, as a support system for tenants who either took their landlord to court or have been taken to court by the landlord. There's also the weatherization, which we have we have a subsection called Push Green. And what Push Green does is they act as a intermediary between NYSERDA and the community. So what they do is they have information relating to different programs that the state has, and they also have the ability to get more information as well. And they relay that information, and they help the community find out if they qualify for certain programs, which ones, and which ones might be the best for that person. And so they kind of take all the information that is really hard to sift through, and you never know what you actually qualify for, and they present it to you to help you understand what your options are with your home. Oh, somebody asking a question? So if there are no questions, I'm going to just get into the last part of the slide here.
I owe you more, but that's what I got on. I owe you more, but that's what I got on. Probably like $30 for almost 40 for a paper. It's still where.
I had a hard time hearing that, whoever that was asking the question, if it was a question. And for the sixth part, it's the Department of New Economy. And what the Department of New Economy does is it studies what different economic models could look like, such as co-ops, and what a cooperative business model looks like, and what it does, and its purpose. And it then works to provide that information to the community and to work with people in the community on educating them on how we can create an economy that runs more cooperatively and more on a level playing field than just a hierarchical of like who has more capital than the other one. And so they work with the community on establishing co-ops and what that looks like and how to effectively run one. And they've done a few workshops themselves around co-ops before COVID-19 hit.
Well, thank you everyone for attending today's training. Like I said earlier, I dropped in the chat a link to the Google Drive, but it's also here and on our website if people want to take a look at what's going on. I put the link up there for us to be able to show our first training recording, but I haven't been able to upload it yet. Hopefully that'll be upcoming early next week, hopefully on our nls.org website. And we'll try and get our partners with Push as well to post it somewhere. We have upcoming trainings. So far, we've been doing every other Friday. Hopefully, it'll be 2 Fridays from now, although we may choose to training if we do. So we'll be sure to reach out to everybody to let them know the new time. Our next training is going to be on repairing and deducting from the rent and what that process looks like. It's obviously very closely related to withholding of the rent, but you know, it's kind of the idea of when you're facing a large condition issue, you choose to do it yourself and deduct that money that you use for the rent. Does anyone have any other questions or comments about today's training?
All right, everyone. Well, we just want to thank you so much for attending today and sharing your Friday evening with us. Enjoy the weekend, and we hope to see you in our upcoming trainings.
Yep.